in Cairo University. He is the chair of the ICC governing body of dispute resolutions. I will have to take it full. And I need to stop, okay, here for a while to congratulate Professor Abdul Wahab on being the first Egyptian and African to be the president of the CIARP in its 110 years of history. So it's an outstanding achievement, not only for Professor Abdul Wahab, but it's for all of us.
But we're also in the presence of Dr. Nail Abeid, who was the first Arab president.
The second speaker is His Excellency Justice Michael Black, KC. He is judge at DIFC courts, arbitrator at 24 Old Buildings Chambers, appointed as judge at DIFC Courts of Appeal and head of Digital Economy Courts in 2022. He is deputy judge in the Technology and Construction Court, London, for 13 years. He is also a visiting professor of construction at University of Manchester. He is an expert in complex commercial and construction arbitration for nearly 50 years, and he is recognized in Legal 500 for excellence in arbitration. The third speaker today, we have Nisreen Osman. Nisreen is a partner at Benson Mason. She is specialized in large-scale construction and infrastructure disputes, representing employers, contractors, and consultants. As a counsel, she handles arbitrations and litigations across the Middle East and beyond. Also, she sits as an arbitrator for institutions such as ICC, DIAC, and Arbitra AD. She is recognized for construction in UAE, Saudi Arabia by Legal 500, Chambers and Partners, and Lexology Index. The fourth speaker today is Engineer Faisal Mu'mina. He is a Chief Commercial and Procurement Officer of Modern Building Leaders, MBL. He is an expert in construction and commercial and contracts management. He is specialized in claim and dispute resolution. His career spans leading developers, consultants, and contractors. He managed high-value disputes and arbitration, litigation, and expert determination, and also he holds qualifications in architecture, engineering, and law. The last but not least, Khushbu. Khushbu is a partner at Al-Tamimi & Company. She advises and represents clients in complex, high-value construction disputes. She also works with multidisciplinary experts and legal teams across multiple jurisdictions. She's a member of a key arbitration legal bodies, including SIAC, Young SIAC, and Clower Arbitration Blog. She advocates for representing and sustainable arbitration practices. And now we will start our panel discussions. So we'll talk about the evolving trends in construction and arbitration. And I need to start with the first question. If you remember last year, this was a very interesting panel to discuss with. So we're trying to keep the same discussion. I was discussing with the speaker that we would have called it Bad Boys 2 because of the discussion. So Professor Abdul Wahab, the first question is for you. What key trends are shaping the landscape of construction, arbitration globally, particularly in the Middle East? And how has the increasing use of technology and digital contracts impacted the dispute resolution and construction projects?
Thank you so much. It's a privilege to be here, and I see a full room, so I'm very grateful for all of you, and very grateful to Saad for the kind invitation, and to Justice Michael for being with us. If you recall, I'll open. Yes. Very bad sound. Go up. Okay. This is better? Oh, okay. Fine. Sorry. So I'm very grateful for the kind invitation. If you recall, last year, we had myself and Justice Black. This year, we needed to be in better company. And because it's bad boys, we needed good females to be present as well. And Mr. Muhammad as well is joining us anyway, and our colleagues. So let me say the following. In terms of the construction industry, what we see today globally, three defining elements, which I consider challenges. One, inflation rates are high, even above pre-pandemic levels. Two, we see supply chain disruptions and challenges that coexist. And three, you can guess the geopolitical tensions that are defining what's happening across the globe. But what I see more interestingly globally, there is one decision that I think is a landmark decision, which may be not known to many of you, that was rendered by English courts on the 20th of June 2024, in the case of Finch versus Surrey County Council regarding the Scope 3 emissions. And for those who are not familiar with that, that relates more or less to climate change and decarbonization, emission-free economies, where for the first time the English court said that the license granted by the authorities in Surrey for the construction should take into effect, in terms of environmental impact assessment, not just the direct Scope 1 emissions, which is effectively what a company controls in terms of the construction of what they do. It was an oil and gas project regarding decarbonization, but also going down the supply chain for subcontractors, transportation and others. You should take into consideration these emissions. So an environmental impact assessment should account for these emissions and take that into consideration in moving towards a zero emissions economy. So I think this is a landmark decision handed down by English courts. We will see how that plays out. That is global. Of course, the major construction players globally remain, of course, India, China, the US, and certain parts of Europe. So we're still not there yet in terms of the region. But since we are in the Saudi sort of disputes week and in Saudi Arabia, giga projects, Saudi Arabia is, of course, alongside some of the other GCC countries, including the United Arab Emirates, leading the pack in terms of the construction industry, with somewhere in excess of $890 billion in 2024, and more than 5,200 projects in the pipeline in the construction landscape. Now, the one thing that I will say in terms of technology, because I think we're also here not just to say things that are actually happening, but to predict what's going to happen in the future. The field is destined for a change, there's no doubt, and technology is changing that. Internet of Things, laser-based technology, and I think the incoming sort of major player is modular construction. Many of you would be familiar with BIM, which is Building Information Modeling. That's fine, it's been around for 12, 13 years. But modular construction is key, which is basically building things off-site, plug and play on-site. This, I think, is going to define, is going to be a game changer in a way. I will shut up there, and I will invite comments from colleagues on this.
Thanks, Professor. I would like to move actually to Justice Michael Black and ask him, from your expertise as a judge and also the arbitrator, how are tribunals and courts evolving to address the growing complexity of construction disputes?
Thank you very much. My contribution is an immediate lowering of the tone from Mohammed, who, as president of the Chartered Institute, has a global overview. I'm going to be a little more parochial. Actually, I hope controversial, because I'm going to break one of the great rules when you're speaking to a room of people, which is not to insult them. I am going to essentially insult the users of construction arbitration. So first of all, though, I'd like to talk about the courts. The courts, and I'll talk about my court in particular, because what we've done is we've followed the English model, and we have adopted a construction division, and which is successful. I can give an example of a case that I'm actually writing a judgment in the moment. Many of you will know the Museum of the Future in Dubai, a great landmark project. There were some issues with regard to the design of the rather innovative cladding in that building, and it's found its way to our court by opt-in. It's subject to UAE law, but nevertheless, the parties decided that they wished to go to a specialized court functioning in the English language, because the construction documents were written in English, but it is subject to UAE law. And so we are something of a hybrid in that we're specialized, but nonetheless we function within the main judicial system. So that's what the courts are doing. The second point is I make good on my threat with regard to being slightly controversial. And basically, I speak for many of my colleagues who sit in international construction arbitration, and we are tearing our hair out. We are trying to make arbitration more efficient and cost-effective, but frankly, it's a difficult task. So I give you a concrete example. One of the things that we've tried to do is to get experts appointed early, and indeed sometimes even to meet experts before the service of pleadings, or even just to direct that experts meet before the exchange of pleadings, memorials, or whatever you wish to call them, so that they can agree things like the method of delay analysis, like even possibly the critical path of the works. And it is the lawyers, and I assume they're acting on instructions, ultimately the clients, who are refusing to allow those things to happen. And frankly, speaking to many of my colleagues, I've been a construction arbitrator for 35, 40 years, and speaking to colleagues of the same experience, we find it very frustrating that parties are actually stopping us, saving them money, and stopping us making the process more efficient. You wanted to be controversial? There you go.
Thank you so much, Michael. So Nasreen, what are the biggest challenging legal practitioners faces when actually handling the construction disputes in the arbitration?
Can you hear me? Is this working? Good. I'm going to lower the tone one further step by giving the lawyer's perspective on all of this. There are lots and lots. I've got a very long list of why this job is challenging for me. I won't take you to all of them. I mean, I'm assuming that most of you in this room have something to do with construction, otherwise you wouldn't be sitting here. The complexity of construction contracts, complexity of construction projects is one of the biggest reasons, and I think probably all of us know this and acknowledge this. They are complicated disputes. They're highly technical. You've got elements of engineering, architecture, project management, all of that coming together in a dispute scenario. Mix that with the incredible volume of data that you have in coming out of construction projects. Professor Mohammed already mentioned about using of Internet of Things and lasers. That type of technology is only going to increase the already enormous volume of data that's involved in construction disputes. Of course, we as the lawyers and the experts and the clients all have to come together, marshal that in some way so that we're able to put together credible arguments and propositions. The fact that construction projects are multi-party, very often, you may only have a dispute between two parties, but we all know that stakeholders in a construction project are numerous in number. And speaking particularly for someone who acts primarily for contractors, that one of the most complicated things that we have to deal with is when you have disputes going up the line with the employer and down the line with numerous numbers of subcontractors. So all of that together makes for a very, very complicated factual and legal matrix. Add to that the pressure to make sure it's all on time and cheap, then the problem becomes even more significant. And I think probably the last point I would add, well, 2 points actually. One point is the contractual matrix. In this part of the world, I come across a unnatural number of badly drafted contracts. I'm hoping none of my transactional colleagues are sitting in the room. I'm purely disputes, I can say that. The contracts are very often not well drafted. Very often they are picked up from the last project, change the names, change some of the specifics, and the same contract is used over and over. And we all know as disputes lawyers, or those involved in disputes, that that is a recipe for disaster. And the final point, and I don't want to offend anyone in this room, unlike you, but the involvement of experts becomes an additional complexity and additional challenge. It would be ideal if every expert we worked with knew exactly how arbitrations should be run, knew their role within the arbitration, and knew the obligations that they had. That is not always the case, and that's another challenge. So, as I said, I could go on about this. What makes my job hard is a long list of things, but I'll stop there.
Thank you so much, Nisreen. I think Michael is coming back next year. You are not coming because you don't like experts. So, Faisal, I have two questions for you. From a contractor perspective, how have the dispute patterns changed in the recent years? The next question.
Start this with the test.
Yeah.
Can you hear me well?
Yes.
Okay, good. Thank you. Of course, first of all, I'd like to thank you very much for providing me with the opportunity to be part of this distinguished panel. And of course, thank the ladies and gentlemen in the audience.
So I think, Faisal, you can hold it and you speak because I think...
Like this?
Yes.
Right. Certainly, in recent years, we have come to observe that contracting parties, whether contractors or employers, have become more open to methods of alternative dispute resolution in terms of resolving their disputes. This includes arbitration, expert determination, which we are seeing increasing nowadays, mediation and other forms. This, in fact, was most notable under the new Saudi tendering and procurement law that came into effect in December 2019. This new law is actually considered a cornerstone in the Saudi Arabian alternative dispute resolution landscape. This is because it granted government entities the right to recourse to arbitration to resolve their disputes. Prior to that, if government entities wanted to resort to arbitration to resolve their disputes, they needed to go through very stringent requirements and approvals, at which time most disputes used to be resolved through the traditional court system. Of course, all of us know the downside of resorting to disputes through the traditional court system. Important to note that in the spirit of Vision 2030, where there is great emphasis on timely delivery of projects, we do expect to see a rise in alternative dispute resolution methods, and that is because of their expedited resolution procedures. So that is what we expect to see in the future. As I said, especially with the introduction of the new Saudi tender and procurement law that granted government entities with the opportunity to resort to arbitration.
What are the most effective strategies for resolving the disputes early to minimize the financial impact on projects?
Financial impact is quite significant, in fact, when it comes to disputes, especially in light of the values of projects that we are seeing nowadays. Nowadays, there is a significant volume of projects that go beyond the billion riyal. So definitely having disputes in such projects will certainly have the potential to cause negative financial implications on the parties. The construction industry, not only in the kingdom but worldwide, is adversarial by nature. And this could be for many reasons. It could be due to the wide range of the parties involved in a construction project, the lack of familiarity of these parties working together. And in the kingdom, it's no different. So in order to resolve disputes, what I'd like to say, and what we focus on mainly as a main contractor, it is said the best way to resolve a problem is to avoid it happening in the first place. So we try to exert all our efforts in making sure that such disputes do not materialize. Since we are talking about early stages, I'd like to put particular emphasis on the pre-contract stage, because that is where a lot of the disputes start from, post-contract. My good colleague here referred to good contract documentation, and that is something that I certainly do agree with. In the early stages of the project or the pre-contract stage, it is quite critical actually to make sure that we've got clear, robust contract documentation. I'm talking about contract documentation that capture the specific project details. I personally do encourage the use of standard forms of contracts. Standard forms of contracts have been tried and tested, and they've learned from previous mistakes, whether it's disputes or they've been informed with best practice. So for example, a good contract, in my opinion, is one where that provides a unified perspective to the contracting parties as to the interpretation of the terms, definitions, and so on and so forth. If we reflect on FIDIC, for example, given its wide use in the region, FIDIC, for instance, provides guidance notes that assist contracting parties in terms of the interpretation of the terms and the definition. FIDIC also provides mechanisms in relation to handling variations, claims, discrepancies in contracts, and so on and so forth. What is important to note as well is that leadership of a project has a critical role to play in minimizing disputes. It's important that we've got project leadership that take initiative and are proactive as well. That is in the sense that they tackle issues as they arise and not wait for them until basically the problem becomes bigger and bigger. So I would say we, from a contractor perspective, always want to avoid disputes. In many instances, we can't actually afford to enter into disputes, and that is because of the relationship management. We want to have projects with our clients for the next 10 years, for example. So winning a dispute now means we lose 10 years worth of projects, and definitely that is not a good business decision. So we don't purely look at it from a legal, arbitral perspective, but rather from a business decision perspective.
Thanks so much, Faisal. I do agree. So, one mic, sir.
And I can speak loudly. I lecture in a 4,000 first students lecture. So I can
So, Khushbu, what the factors contribute to the increasing complexity of construction arbitration? And also, how can legal professionals streamline the dispute resolution to improve the efficiency?
Thanks very much, Saad. I can't speak as loudly as Professor Abdul Wahab, so I have to use the mic, unfortunately. But I think it's implicit in that question, Saad, that construction arbitration is getting increasingly more complex, and definitely I would agree to that. But whose perspectives are we really talking about? And if we really want to pinpoint the factors that has led to this increased complexity in recent years, we need to take pause and really think about who are the stakeholders involved in the construction arbitration and how their mindset turns to a dispute. I agree with Justice Michael Black's statement, and while controversial, I think he alludes to something a little bit more deeper pertaining to the dispute resolution process and the inherently adversarial nature of construction arbitration. And this is exactly what I was going to talk about, and I think he did half my job, really. And I think from the arbitrator's perspective, and Professor Abdul Wahab and Justice Michael Black both would agree probably to that, is a criticism that's often been levied against us as legal representatives, against the parties, and against the experts as well, is that the analysis of both the experts are like ships passing in the night, which basically means that they sit down, these two experts, in the very beginning of the process, during the joint statement, and then never again. And they go on their own tangent, doing their own thing with the analysis. And then at the end, when we come to the hearing, both the assessments just don't correspond. So it's very difficult then for the decision-making, the tribunal or the sole arbitrator, to really think about who's right and who's wrong. When it comes to delay, when it comes to quantum, we've seen this quite a lot, but when we are thinking about BIM, for example, as was alluded to, or the more 3D, 4D kind of construction issues, it gets very technical. It gets so technical that it's difficult then for an arbitrator to sort of come up with a proper solution. And just to give probably some examples is that in a recent case we had with some of the experts here in the panel, the direction came probably 2 or 3 days before the hearing from the sole arbitrator for the experts to comment on each other's delay analysis methodology, because both experts used very different methodology in their critical delay parts. And to assume the other methodology was right and then sort of do their own assessment based on that. And even though it looked like a really difficult exercise, in practice it really wasn't, because it was just a matter of criticizing or commenting on the other experts' analysis, which could have been done quite easily and was done. But the problem was that this direction came 2 days before the hearing and 4 days before the delay experts were due to testify. So was that the right time? Probably not. So the long and short of my response is that I think more control and directions need to be given by the arbitrator. It's difficult for us to do this control because as lawyers, we have differing obligations to our clients, to the experts, to the arbitrator, to the process itself. And because we have these, I wouldn't say conflicting, I'd say differing obligations, it's not really for us to streamline the proceedings and the process. It's more for us to make sure that we strategize as best as we can and put our best foot forward. So from my perspective, this really needs to come from the tribunal and arbitrators.
Thank you so much, Khushbu. Let me move back to Professor Abdul Wahab and ask him maybe a little bit different question than the last stream. How do arbitrators assess the contractual risk allocation in dispute?
Thank you very much, Saad. Before I do that, I would like us, one of the things that we can benefit with a room full of diverse people with different backgrounds is that looking at the root cause of construction disputes. And I think there was a very recent study for about 500 projects comparing Europe, the Middle East, and KSA, since we are in KSA. And of course, the usual suspects for those causes: design, change in scope, payment issues, name it, and these are by and large the most common elements. But design was very interesting because design included incorrect design, incomplete design, and delayed design. When you look at Europe, surprisingly, it was incorrect design that reached around 17% of the disputes. For our region and KSA, it was incomplete and delays in designs, coupled with variations in scope. Why? Because if we want to be candid, because this region likes to build things bigger and better so that everyone wonders about the wonders of the world that we see in the region. So pretty much it is an effect of that. But combined together, incomplete, delayed, and incorrect design account for no less than 78% of the disputes in the region, including KSA, and 59% for Europe. Now, when you look at that, to go as a segue into your question about the risk, one thing that, in a way, distinguishes legal practitioners in the construction field and also is a cause of great concern, and I would say is not a sustainable practice, is the disinterest legal practitioners show in the work of the experts. Very simply, and it becomes a question very simply for law firms, we do the work legally and the experts do their work. Something goes wrong, it's the fault of the experts, it's not the fault of the lawyers. Experts can go rogue, and that goes to Khushbu's point about early engagement of experts. One of the things that I do and I encourage in various capacities and hats is that experts should agree on the methodology. And I can tell you, I refuse to accept that experts cannot agree on the methodology. Experts can disagree on the application of the methodology, but if they disagree on the methodology itself, then you need to call them into a procedural hearing, put them back on track, but you can only do that if you as a construction practitioner understand methodologies regarding delay and disruption and otherwise, because otherwise you will not be able to steer that in the right direction. So that's one of the first risks and challenges, and that's why legal practitioners who have an interest, an expertise in the technical aspects of construction experts are heads and shoulders above other practitioners. At the same time, if legal practitioners do not engage with experts by knowing what they do, I am telling you that in time as it is happening, and I am not against it, despite having a legal background, experts are going to take over because many of them are getting law degrees. So as a matter of fact, they will have double measures in law and in construction-related aspects. So it's up to you whether you want to give up your business or not. Now,
we can share, Doctor.
We can share. No, it's a good thing. And that is a field. Honestly, you have to give non-lawyers a leeway. You do it in energy, lawyers, they tell you legal practitioners. But the construction industry, you need the experts, the people who know the stuff technically. So it is only befitting that they get a proper share. And many of them are getting paid more than lawyers because of the work they do, because they have created, and I admire that, a situation where the industry makes expertise indispensable. You cannot run a case claiming, for example, prolongation costs without proper analysis through experts. You will not succeed. So the days where lawyers would say, oh, these are the defaults, and we're claiming millions, and the tribunal has the discretion, and you find your way around that, are long gone. So you need to have proper experts in that sense. And the point about the risks, briefly, is that one, again, looking at the main causes of construction disputes, wrong choice of contract, that goes to Nasreen's point about poorly drafted contracts, and Mr. Faisal's point about contract administration. Believe it or not, that again in this region, the Middle East and KSA, poor management of construction projects accounts for no less than 20% of the disputes. So if you look at the design and the management of the construction projects, accounting for more than 80%, you manage those two risks properly, you dispense with at least 80% of the disputes, at least the major ones. Now, the reality is imbalance in rights and obligations of contractors, employees, and subcontractors. People in our region, and we are not alone, in certain parts of Africa, certain parts of Latin America, the mark of being an excellent negotiator or a practitioner is that if you pass on the risks to others, so that you get all the rights, much less obligations. That is a clear recipe for a disaster, not for a dispute, for a disaster. Because effectively what's going to happen during the implementation is that it's not going to work out. And then you'll have one of two options. Either you shelf your contract, and then we manage the project without looking at the contractual document, or we amend the contract, or we go to war through arbitration. And I know that in certain parts of our region, the leverage and the ability to negotiate terms is not available to everyone. Across all levels, engineers, project managers, suppliers, subcontractors, contractors. Sometimes the employers have much leverage, or sometimes the contractor as well. So in reality, you need to create a balance. And one advice, since Faisal has mentioned the FIDIC, which is widely used in our region, when you decide to tamper with the risk assessment matrix in FIDIC, be careful, because that is a surgical intervention. If you do it without the necessary and requisite expertise, again, you are effectively creating a monstrous document that will not live through the project. The last risk that I would highlight, and that's normally not in books but in reality, is be realistic about expectations. You want to build something bigger and better, you need time. You want it to be expedited and accelerated, you need to put in more money. Cash flow is a major concern. People come in during the honeymoon phase with a perception that we will have the money, we will have the ability, we're going to build this together. Down the line, payments, certification, cash flow becomes a major issue. Contractor is unable to withdraw. The employer doesn't have money until you reach and you hit the mark of about 96, 97%. You get terminated and the bond called. Very interestingly, in our region, and again, that is a latest study, termination and calling of bonds has become a feature. Where are the good old days when people used to think before calling in bonds? This is a serious measure you would take only when really you have assessed the risk and realized that you have a right to do that. But arm twisting, in a way, doesn't help anyone in that sense. So we need to rethink the matrix of risks and our approach to projects at large before we try and resolve disputes arising from that.
Thank you so much, Professor. I just need to highlight two things. The first about the practitioners in arbitration, and since you are the president of the CIR, the latest survey showed that in the CIR members, we have 48% of the members and fellows across the world of 19,000 members are construction practitioners, 37% are lawyers. So we already started to dominate the... The second one, I like what you have talked about the experts and the bad management of the projects. There are two elements here. I do agree that the design consists a major issue of dispute, but when even we starting going into disputes, we discover that the bad management or poor performance of management or managing the projects increasing the problem of the design more and more and more. So it's creating, I would say, like layers of complexity on this matter. So I would like to move to Justice Michael, and building on last year. And at the event of last year, I remember you said that you thought that the current model of construction dispute resolution is unfit for purpose. So what did you mean by that?
Well, first of all, I've got to say that I really, really hate being on a panel with Mohammed, because he says everything I'm going to say. So in future, can I speak before you rather than after you? Because I agree with every word you said, and particularly I pick up also from what was said on my left and Mr. Faisal. Can I roll matters back slightly, just to go back to the nature of contracting in the region and the adversarial nature of contracting and the forms of contract? You spoke about the FIDIC suite. I mean, one thing that we don't see in this region, which has been, to my knowledge, highly successful in England, are partnering agreements where the risk is shared more equitably between the various participants in the project. And what we do see is what Mohammed characterized as perhaps what I would describe as highly muscular negotiation, where often the employers, who are state entities, do exercise considerable leverage to de-risk, and the de-risking process then turns into a cascade all the way down the subcontracting ladder, which creates problems of cash flow. It was a great English judge, Lord Denning, that said cash flow is the lifeblood of the industry when talking about construction contracts, and that's absolutely true. So that's one element, I think, of the if you like, the contractual environment that could change and might change. Another is that I've seen a certain amount of resistance in this region in large infrastructure projects, even in large infrastructure projects, to the use of dispute review boards or dispute adjudication boards, which can head off these issues before they ever get to the dispute resolution process. But again, for some reason, whether it's main contractors looking at subcontractors or employers, they feel that there is no gain there by spending the money at an early stage to set up a procedure that can avoid large costs at a later stage. And that probably typifies an idea in construction that if we can save a penny today, we won't worry about losing $1 tomorrow. You know, that has ramifications further down the line. So that's one of the contributory factors that I think we've all been, in our ways, discussing. The other contributory factor to the unfitness for purpose that I described as the use of experts. Again, we've also described that. I mean, I find we don't use experts enough, actually, in construction arbitration. We don't make good use of the experts. We've spoken about getting the experts to meet early, to agree methodologies. I agree 100% with Mohammed, particularly in delay in construction cases. It should be possible, with the benefit of something like the SCL protocol, for the experts to be agreeing the methodology to be applied. And as I said, even hopefully agreeing the critical path even before the cases are pleaded. If not the critical path, at least alternative critical paths, or even agreeing just that the frag nets for particular activities would be helpful, but that doesn't seem to happen at an early stage. And yes, you do need specialist arbitral tribunals who can understand what a critical path is, and equally can understand when somebody is trying to blow smoke in their eyes when they're trying to convince them that delay has happened and disruption has happened. So, you know, those things are necessary. And so we do need to change because it is costing the parties too much, and they're taking too long. The typical construction arbitration, at least as I do, and I admit that I probably do the larger cases, but they're taking 2 or 3 years from the constitution of the tribunal until the final award. That's too long. It should be shorter. And we've got to find ways of shortening it, and we've got to find ways of making the whole process cheaper. De-risking, certainly, or the sharing of risk and the use of experts, it seems to me, are areas that we ought to be looking at.
Thank you so much, Michael. But I want to discuss a point with you before you and Dr. Muhammad, before we're moving to Khushbu, about the costs. You both said that you agree that you want to engage experts and at the beginning, then encourage them to do what's called joint reports and agree on methodologies, agree on the first stages and critical passes and stuff like this. But there is sometimes a limitation forced to the experts by their clients or the instructing lawyers, specifically on cost. Because as you know, there are some elements in such disputes that expert cannot actually exercise all what they wanted to do in specific disputes. So how can we manage this?
Michael can go first.
I knew that was coming. I knew that was coming. Look, the question is, there has to be a realistic engagement, ultimately by the clients, in understanding, as I said before, that you may have to spend some money up front instead of just closing your eyes and putting your fingers in your ears and hoping it'll all go away. It demands a mature approach to the dispute resolution process, which sometimes, sadly, is lacking because yes, of course, it has an impact on cash flow, and expert evidence can be very, very expensive in construction arbitration, if you'll forgive me for saying sometimes too expensive. Not, of course, you, but other people.
I'm expensive. It's
yes,
okay.
of course. But, you know, I have certainly seen, when I've come to assess costs as an arbitrator, I have seen the experts' fees far exceeding counsel's fees. Which I'm not sure is right. I'm not sure should be the case. No. Both of which were in 7 figures.
Yeah,
but it does demand, I think, perhaps an education of both people working within the employers, often within government, and people working within the large contractual organizations, although they are perhaps better educated, to understand the dynamics of the process and to understand that you can't hope that it's all going to turn out well in the end, and therefore nickel and dime at the early stages.
So here is my 2 cents, and I fully agree with what Michael has mentioned, but here is my 2 cents, and I will say something different. And I don't think it has been said in the world before. So building on Khushbu's point about experts, ships passing by night, different methodology, different outcomes. Now we all know when you work closely with construction experts that they use software programs. And they have safeguarded their territory through the SCL protocol with 2 words: the common sense approach. So the element of delay analysis, identifying the critical path, looking at dividing the critical path into specific windows, That is the element, the first. I'm going to talk about the tricks that the experts do. How you define the windows will determine the outcome. So that's one thing. Logic links and floats and all that aspects. So fine. But in reality, AI is going to also do that. And the common sense approach is going to slightly regress in that sense. But the additional aspect to cure the disease that plagues the industry, that we see both in terms of time and cost, and that is inspired by the latest breakthrough in cancer treatment. They found that the best way to treat cancer, which is in many instances untreatable, except that you try and treat the symptoms, prolong the life of patients, is through what they call removal of polyps. Polyps medically are tissues that are growing over the body organs. And so the surgical intervention by removing polyps, colon, rectum, or whatever, is the best way to avoid cancer, because cancer grows through these polyps initially and then eventually becomes malignant. And so inspired by that, and since experts are indispensable in the construction industry, and here is the part that has not been said, what we do today is that each party hires experts, and we like that, and that's good. No, don't worry, you're not going to go out of business. Don't worry about that. And that's fine.
This panel started as with the experts, then now I feel it's anti-experts.
No. I'm all for experts. But I'm going to tell you how to do it, because at the end of the day, they are the users. We say that there is a problem, we need to offer some solutions. So reality is, and I'm making this as I go because I'm thinking about the solution, is that, okay, so what happens is that you had the hired experts. Of course, in our jurisdictions, they tell you, you cannot consider that as an expert because that is appointed by a party. You need a tribunal-appointed expert. I'm not normally in favor of that. So for our common law colleagues, that's a blessing, because at the end of the day, extra cost. You have party-appointed experts, tribunal-appointed experts, and then adds insult to injury in that sense. So in reality is, unless of course the experts are hopeless, if the parties have not invested in getting experts, then there is no option but the tribunal getting experts. Now, what I propose is the following. What happens today is that the experts work with the parties, and they tell you, but they are hired guns. And I will say, so what? So what? Of course they are hired guns, but there is a hired safe gun. An expert, a prudent expert, will tell the client, this is as far as I can go. If I go beyond that, I lose my credibility. And the last thing a prudent client would want is the expert losing their credibility, because they're going to be grilled in cross-examination if you have a good cross-examiner. Now, the reality is they can be that and do it. But what's going to happen, again, in some parts, is that the tribunal at the time post-hearing, they get the experts to work with the tribunal independent of the parties. That's not new. That's happening. Some are against it, some are with it. My proposal is that take a step back, and that's the new thing. From the very beginning, the parties were going to instruct experts, right? So, the tribunal in the first procedural meeting meets with the parties, tell us 2-3 names of the experts that you intend to instruct. And the other party, 2-3 names. Meet with the parties, they have not been approached. And if both parties agree on 1 or 2 experts, tell them fine, from the beginning, not at the end. They're not going to be your experts, you have chosen them. They're going to work with the tribunal, 1, to develop the critical path with your submissions, with your in-house team, but they're going to be with the tribunal from day 1. Believe me, that's going to cut time and cost. Only if you have the will to accept that because the parties have chosen those experts, and they will have ongoing meetings with them, and that will also kill the whole debate about early engagement, because they will be forced to engage early. They will not have the pressure of a party imposing on them. They will have the ability to credibly present work to the tribunal, and everyone ultimately will be getting the benefit out of this, rather than waiting until the end and putting more time and money into it. Think about it. I'm going to think about it. I'm not presenting it as the ultimate solution. but it's something that I think worth consideration.
One comment, if I may. Your analogy of cutting out polyps before the cancer starts, I thought you were going to agree with me that the cancer is a dispute. One way of cutting out the dispute before it even starts is a procedure like you have, like you've described. But that's a dispute adjudication board. You have a dispute adjudication board with experts on it. It may be chaired by a lawyer, but you may have 2 or 3 or 4 experts in the field who understand the critical path as it's evolving. And so by the time you reach a dispute, it's all crystallized even before you get to the arbitration. So maybe even your idea, but one step back, and the opportunity exists already, but it's an opportunity which is not being taken.
100%, and I fully agree. The issue is that works well, for example, in the UK, in Malaysia, where you have the adjudication regulated by statute. Now, that part of the world, or our part of the world, does not have adjudication regulated by statute. The system is binary in our part of the world. We either recognize an arbitral award, or you have everything else, mediation, amicable settlement. So one way, to build on Michael's point, which also I like, is that maybe it's time to consider statutory adjudication to bring in that into our part of the world and accept.
But even contractual adjudication.
Yes, but it's not going to be qualified for enforcement as an arbitral award under the New York Convention.
I agree with you on that.
So that is the loophole. So you're going to go into a dispute in that sense. But I agree, and the Dispute Avoidance Board is one way to do it. But not everyone plays by the rules of the game. Contractors in that sense are much faster, more agile, ability to present claims. Now, in reality, contractors put forward claims, and that's understood. How many of those claims go through the proper process, through using a FIDIC mechanism or an engineer independently verifying, wearing the hat of an independent sort of assessment? Not many. And ultimately, you hit the wall with the dispute alongside. Now we see even disputes against the engineers, the accusations by everyone blaming the engineer, who, by the way, does not feature in the arbitration. So everyone is blaming the engineer who does not feature in the arbitration.
I'd like to comment here,
Yes.
Saad, if you don't mind. It's in relation to what our well-respected colleagues have mentioned. In my opinion, from a contractor's perspective, I actually tend to have an opinion to the contrary. I personally believe that involving lawyers and arbitrators in the early stages of a dispute or early settlement sometimes actually doesn't work for the favor of the contractor. And with all due respect, this could be due to self-interest. Self-interest in the sense that basically if you appoint a lawyer and the lawyer first day says, you know what, I think you haven't got a dispute, you can settle it easily, then it means that they are out of work. And if the lawyer is out of work, then basically what is it that they've got to do? In here, I'm talking with all due respect, but I'm only reflecting based on real experience in the kingdom in projects. Of course, with all due respect to the integrity of all the lawyers and the professionalism, and we certainly value what they say. However, I have come personally very recently across certain scenarios where the in-house teams of the employer and the contractor could resolve the dispute easily. However, because we appointed those very expensive lawyers, I'm talking about the ones that charge £1,000 per hour, they actually,
Not expensive.
for us, we are contractors, so for us it's expensive.
No, I
For you, I'm sure it's not.
No, I'm joking. That's a joke. Of course it's expensive.
He charges more than that.
No, I don't.
I'm sure he does. That's why he's pro-disputes.
No, I like now the engineer is fighting back, like not only the lawyers are criticizing experts,
I'm not a lawyer myself, I'm not an arbitrator, but I'm giving the perspective of someone who's dealing with these things on a day-to-day basis. And yeah, so basically going back to that particular scenario, I was very confident that due to the very good relationship we have with the client, due to the amicable means through which we would always resolve disputes, The client decided to appoint these expensive lawyers. Subsequently, we decided to appoint these, and guess what? The matter is still not resolved, and it's been 2 years. And we've paid maybe 20, 30 times what we should have paid had we resolved the matter amicably. So what I'm saying in here, I do like lawyers, I do recommend the use of lawyers, but not early stages. Early stages, let's try and do it amicably, friendly, because the moment you appoint these people, believe me, you will go into another
I'll
dimension.
leave Khushbu to comment, but that's extremely
With all due
helpful.
respect, please.
No, it's, Mr. Faisal, it's extremely helpful what you say, and I must tell you, and that will not be a surprise to many, you're absolutely right. But let me tell you, I was speaking to a colleague before we start the panel precisely on that topic. That is, where do you draw the line between a lawyer's duty to the client, which should be more or less unconditional, except if the client wants you to do something wrong, versus self-interest? And the reality, as you put it forward, is that in many instances, lawyers think that you would be out of business if you settle early. I will start with the last part.
That's the exact
I
point I'm
completely
referring to.
understand. And that's why many of them are against mediation.
Oh, yeah,
Because I tell you, mediation doesn't work. Now, in reality, is you say, let's bring in the lawyers late, which is basically bringing arbitration late. Let me tell you this again using a medical condition. The last thing everyone wants is surgery. Arbitration is surgery. You make incisions, it's battle, blood will be shed. Now, the last thing you want is to bring that option later, because then the lawyers will tell you, oh, you did not involve us from the very beginning, you have mismanaged the communication, you have written emails and letters to the other party, waiving rights, or did not emphasize a certain aspect of a breach, that the tribunal, when they consider and will look at the contemporaneous record, will consider that you have missed on this point, so it might not have been that important for you and the common intention, and you will pay more as well. I think the best way, one, you need to have good in-house team initially. But I think the best way is that lawyers should understand that their duty is to the user and the client. You cannot promote your self-interest financially ahead of that client. And I'm not saying that as a saint, but this is normally what we do, because it will allow you to focus on the other contentious matters in that sense. And that is another duty that lawyers have, because lawyers who go down the path of not being candid with the client about their best interest will also fall into the dark realm of telling the client, one, you may have a good case, because then that's a cash cow, you pay more and more, and ultimately the client loses rather than being candid from day one. So I think that goes borderline ethics and integrity, which I think lawyers should consider carefully. Now that said, lawyers in international firms, and I was talking to people in my team, are under, partners in international firms are under very serious pressure to bring in work. They are required to meet certain targets in hours and in money, and they are competing with each other over work that is becoming exceedingly very competitive. So you're right about the problem, and I think it's important to have an open dialogue about what the client expects. But let me tell you, the more sophisticated the client is, the less likely a lawyer will be able to fool them.
Can I just comment on Faisal? And with all due respect, Faisal, I agree with everything that's been said, but I think the starting point that is, as lawyers, and I can't defend every lawyer in this room, I can only talk about a handful. Even if we settle a case, though, and I can tell you, firstly, you should go to lawyers that are busy, because trust me, I can tell you this from my own personal experience, settlement is always the first thing we talk about, because we're helping
All of
us
them
if we
claim to be
settle it.
busy, of course.
But we want the client's work for, not just for that particular dispute. If we get you for good as a client, we have you for employment, for corporate, for labor. So definitely, I don't think anybody wants to prolong the proceedings. I mean, getting lawyers on board early doesn't mean we need to draft the letters. And oftentimes, we are sort of back doing the work from the back in the scenes, because we want you to draft those letters. We don't want the other side to know you even have lawyers, because as you rightly say, it gets aggravated unnecessarily. So that's a tactic which you can put in as the client, as the contractor. You put in the barriers to tell the lawyers to draft your letters, but you issue it from your letterhead, from your company. And that way you control the process a bit, and if there's a chance for amicable settlement, you take that. But when it comes to early intervention, I was going to make a point which Professor Abdul Wahab already mentioned, but if there's a risk, for example, in the contractual clauses, and as Nasreen mentioned, it's very common in this region, the risk can be mitigated, not completely, but to some extent, if from very early on the correspondence that are being issued shows how you interpret that clause in your own way, and or if it's an invalid clause, you make that point very early on, you can mitigate that risk. So maybe arbitration is inevitable. Sometimes it is, even though we try our best to resolve it early. But what it shows the tribunal and the arbitrators that you took position from early on, you're not changing position in the dispute. And that's exactly the key why you need to make sure you have good in-house lawyers or external counsel for your correspondence drafting. Because oftentimes the issues come when we read the correspondence so late in the day, and it's a terrible position that's already been taken, and we can't undo it. We're not magicians.
But to be fair to Faisal, he said he loves lawyers, by the way, and he's, I think, the first
I don't
guy
believe
who said
you.
it. He's the first person he said so, you know?
If I could maybe just add one other thing. Just because a lawyer is expensive doesn't mean they know what they're doing. Just a message out there, right?
Well, I'm sure about that.
Yeah, I suspect you've experienced that. And just to defend us poor lawyers a little bit in this room, what we do in terms of arbitration is well known, and we're talking a lot about that. But a lot of what we do is also during the project. Khushbu's mentioned a little bit of it. A lot of my clients bring me on 2-3 years before the disputes actually happened. I sit in the background. I read correspondence when they want me to. I don't. I'll turn up for a meeting every few months, see how it's going. But the important thing is, when there comes an important decision to be made about a big variation, an extension of time claim, we look over it and we give advice to guide, like Khushbu says, so at the end, there hasn't been an almighty mistake that has to then be unraveled in arbitration. The other point here as well is that arbitration may well be inevitable, but actually this project counsel type of role is probably one of the most important things that we do. And we do it on the basis that we don't want the client to go to arbitration, so that your position at the end of the project, and let's face it, a lot of the disputes that we see are final account disputes. Everything's been left to the very end. Quite often, the delay analysis that was needed hasn't been done. To avoid all of that, the advice that we give during the project is almost as important as the advice we give during the arbitration. But as I say, you need to go to lawyers who know what they're doing. They do not need to be expensive lawyers. I mean, there are plenty of them. But the lawyers that genuinely know what they're doing, and it's our interest to maintain a relationship with the contractor. It's not in my interest to take a contractor down the route of a really expensive arbitration for years that they may win, they may lose, but they won't like me very much. It's in my interest to help you throughout the entire duration of all your projects. So self-interest is an issue, I suspect, in our industry, particularly from the lawyer's perspective. But actually, it's finding the right ones that suit your business, that understand your business, that can work with you, which is what we try to do.
Certainly, I do appreciate what you ladies and gents have said. But you see, the beauty about this panel is that you've got people talking from different perspectives, and that's why it becomes more informative and insightful to the audience.
Yes.
Because if you were all lawyers, no one would bring up this topic, for example.
Exactly. And this is remind us, like, you know, you went directly into the nest, you know, like we have been grilled as an experts for like 1 hour and nobody spoke. Once you want about lawyers, you have 4 people speaking.
And let me tell you, a smart lawyer acting out of pure self-interest would actually encourage a settlement to win the client for the future, because you're going to do business in the future with them. When they trust you, they're going to come back.
I think 70% of the dispute business is recurring client. Like once you secure the client and you are good and he knows that you actually working for their own interest, not your interest, so they keep you and they give you more and more work. Let's change the subject a little bit, but I will just say one question, but I'm not going to answer it now. Let's answer it at the end. I remember the discussion last year between you and Michael in relation to the arbitration and the other form of dispute resolutions. And there was a question, it's not answered till now, is really arbitration is the solution? Is it better than the others? But let's park it now okay, and answer it at the end, okay? So I would like to ask Khushbu another question in relation to the, since we are speaking about experts and, you know, construction, what is the best practice in managing what we are talking about?
What? See, okay. So what is the best practice in managing the variations, delays, and extension of time?
But can I just take the time when answering this question to talk a little bit about what Justice Black has said earlier? And I think there was so much to unpack in the criticisms against lawyers in the arbitration process, mainly about the time. And he's right. I mean, all my bigger cases, 2.5 years is actually a conservative estimate. It's probably 4 years to be accurate for the more giga projects in the region. But it's not necessarily just because of lawyers. You know, there are some times where the tribunal gives us a timetable or the hearing dates where they are so busy and the dates just get protracted because of their availability. Now, that's a criticism which the arbitrator community needs to work on, and it's something which, when I sit as an arbitrator infrequently, I see the same thing, especially with the more senior arbitrators. Timetables just get packed, and that's something for us to think about, that are we relying on the same pool of arbitrators again and again? And if so, why are we doing this? Because back in the day, the typical custom was to hire the most senior partner or the senior barrister as our arbitrator. We don't need to do this anymore. And we don't need to do this because there are so many good independent arbitrators in the market now. It's a very different landscape from what it was 5 to 10 years ago. I mean, the other thing I want to maybe share a story is that we do a range of disputes in the firm. We do the big ones, but we also do the smaller to mid-value ones. When it comes to a construction dispute, even though the value of the claim sometimes is not 100 to 300 million USD, if it's even less than 100 million, the processes don't really differ. And that's because an arbitration is a protracted process, because it's adversarial, because we all have to go through the drills. The experts need to do what they do. We need to do what we do. The clients need to do what they do. So because the processes don't really differ, it's not really fair for us to try to streamline the timetable just because the claim value is less. And in a recent case, we had a prominent, very prominent arbitrator try to do this with us. It just didn't work. The first submissions went in from both sides, just really, really messy, because no one had the time to organize ourselves. It was the first time anyone, the lawyers team and the experts, were looking at really the facts of the project team. And oftentimes, the legal team sitting in one city or one country, very far away from the project team. So our job as lawyers is not really just getting the instructions from the legal team or the in-house GC. It's also about really uncovering the real story, not what's written on paper, but uncovering the real story from eliciting them through the project team, through interviews with the right people and getting down and dirty with them. So this whole process takes time. So I really don't think timelines can be condensed. Maybe in some cases they can, but in a lot of them, the value of the case has very little to do with the processes. Now, this boils down to then what can we do, right? Because obviously 4 years is unacceptable for everyone. There needs to be a different process. It needs to be a different system for smaller and mid-value disputes. Arbitration can be used, maybe for the more larger, complex cases, but arbitral institutions, the stakeholders need to really think about whether the rules are accommodating smaller to mid-value disputes. And I think we see this a lot in the arbitration rules. The SCCA, for example, has had this provision from 2018. It's called the Online Dispute Resolution Protocol. It's actually a step even below expedited provisions, where if the value of the dispute is 200,000 Riyal or below, you go through this very automated process. The language is in Arabic, you see this Riyadh, very streamlined. The new Singapore International Arbitration Rules is something similar. So again, below expedited proceedings is called streamlined. The threshold for that slightly higher is about 2.8 million Riyal. But there's no reason why the threshold can't be increased. In fact, they should accommodate to 10 million, 20 million, and that's when we'll see the mid-value disputes getting resolved a little bit more effectively. So again, long answer to a very short question was that because we need time to strategize for all of these claims, whether it's EOT, it's time, it's cost-related coming from delay, it's all very complex. I mean, time itself doesn't necessarily give you prolongation costs, is what I was saying yesterday in my panel, because we need to think about compensable delay, non-compensable delay, and all of this just takes time to strategize. Sometimes the baseline in a project isn't detailed. But that doesn't mean we all give up. You know, there's progress records or there's updated programs which can be more robust, which can have more detailed breakdown. So we need to sort of locate those, strategize on those, and that just takes time and nothing else.
Thank you so much, Khushbu. Any comments from Nasreen, or shall we move? Okay. So, Nasreen, I would like to ask you, because you spoke previously about the contracts and contractual elements. So, what is the contractual pitfalls should parties avoid when actually drafting the construction agreement?
Well, we've addressed quite a few of them, actually. Things like incomplete design, for example. You can avoid a lot of problems, as has already been discussed. Sorry, I'm trying to hold this thing whilst also speak. You can address a lot of the risks by making sure that when you start your project, your design is complete. The drafting of the contracts should be clear, especially provisions, important provisions like delay, payment, it's okay, changes, how they're to be dealt with. We've also spoken about one-sided risk allocation. Really, the party that can best bear the risk is the party that should be allocated the risk. That doesn't happen very often out here, as we know. So to avoid the pitfalls, properly allocate the risk so that the party that has that risk has a good chance of bearing it. There's two other points. One sort of relates back to what we're talking about why these disputes come about. And actually, one of those is the ability of the engineer to make decisions. I've seen contracts out here, FIDIC, etc., where the engineer's independence is struck out. That cannot be a good position to be in. I think if parties or the employer was to empower the engineer to make sensible decisions, feeling like they're not going to be punished for it, then that would go a long way. We've spoken about the problems in relation to administration of the contracts, but if the engineer has no power, does not have to be independent, is required to go back to the employer for just about every decision, that's not going to help your project, and it's definitely going to lead to disputes. And I think the other pitfall, the final pitfall I would mention is how you draft your dispute resolution provisions. That is probably, at least in my world, one of the most important elements. And I'll give you an example. I saw a clause recently where the dispute resolution provision obliged parties to go to arbitration in Saudi under the Saudi arbitration law, the ICC, and the SCCA, all in one clause. I mean, that is just not an operable provision. So
Is diversity? Or
diversity.
inclusion?
Exactly. So as long as we have provisions drafted like that, all you're doing as a party is creating more and more problems for you before you even start the real detail of your dispute. So in terms of pitfalls, there are plenty of them, but properly advised, clients should be able to sidestep a large number of them.
Thanks. Is it on? Yeah, okay. I'm really old, okay? And when I started out doing construction projects, there was an engineer. The engineer designed the project. The project then went out for tender against the engineer's design. The tenders then were assessed, and then the engineer supervised the construction against the engineer's design on the basis of the tender, and there were bills of quantities, and it enabled variations to be varied and so on. That's dead now. Now, of course, the fact is that design is much more diffuse, and that's a real problem. You say, finish your design, before you start the project, but many forms of contract actually include a design element which is then subcontracted. So you have an employer which then sets out, gets a very expensive firm of international architects which produce absolutely beautiful Rhino 3D models of an exquisite development, but they have no idea how it's going to be built. It then goes to a main contractor who has an idea of how it's going to be built, but not how it's going to be designed. And then there are subcontractors who are going to actually be doing the design. But the project goes out for tender at the concept stage. And that's the real problem. And those are all driven by financial concerns and also the desire, particularly of employers in this region, to have these landmark projects designed by these very, very famous architects who have no input into the constructability of their own projects. And it's a recipe for disaster, and I see it time and time and time again in this region. I don't know whether other people have similar experience or not.
I mean, I think that's absolutely right. I think where we see a lot of problems, design development, quote unquote, is the basis for so many of the construction disputes that we deal with. One extreme is that you have a traditional contract where the contractor's turning up thinking they're just going to build, but somehow they've managed to write into their contract all responsibility for design that they did not design. That's one extreme, and we do see that quite a lot. The other extreme is where it's a pure design and build, where the contractor takes on all the risk. Again, there's lots of problems. But the real issue is that there's so many contracts that are in the middle, as you've said. And those contracts where we're in the middle, where the design responsibility sits with the contractor, but they've been given something that actually, even at concept stage, the employer changes their mind about that concept. And then it goes on to the subcontractors who have to do the detailed design, and actually they now don't know what they're doing, but they've quoted for something that they're now not actually designing. And that's what I mean about clarity. If you have all this ambiguity, of course it's going to lead to design issues and claims. But I think the solution to that is an acknowledgement by all parties that that's the position we're in, and perhaps the partnering type contracts that we were talking about earlier are the way to deal with that. So a grown-up recognition at the start of a project that we have a complicated design. We're not going to use the traditional style of contracts. We're going to do something slightly different for this region, which is partner and accept that there are risks and share those risks. That doesn't happen very often, and it certainly doesn't happen for the big projects that are happening out here.
Can I mention 3 tips in practical aspects for the drafting? And then I'm going to be theoretical. One, as Nasreen has mentioned, and building on another comment that Khushbu has mentioned, in the US and in other parts of the world, thank you, in the US and other parts of the world, saying, you want to get things done, give it to a busy person. And I tend to think that that is correct, actually, because they don't have time to waste, and they will probably know what they're doing, because they're busy, presumably, with expertise. And so if there is a settlement, they will settle. The same thing as you say for a lawyer, and also for arbitrators, because in reality, and I've seen that in practice, if you're busy with a certain practice, you don't have to waste time on other matters, assuming, of course, you're organized. But in terms of the drafting, there is one developing, recurrent drafting that I see in clauses, which is a contractor is not entitled to bring arbitration before project completion. Be extremely careful with that, because in reality, you could be terminated, the project still ongoing, another contractor hired, and you will have an admissibility or potentially a jurisdiction objection, depending on the jurisdiction and the legal system, whether to bring arbitration or not. So be careful with these clauses, be careful what you wish for and whether you accept it. And the other thing, the last thing in terms of the drafting as well, is the back-to-back arrangements between a contractor and an employer and a contractor and a subcontractor. Because that is a cause for so many disputes. You call them back-to-back, but they are separated, light years apart. And thirdly, in drafting, when the employer insists on a subcontractor, then it should be a nominated subcontractor. Because in reality, they would force you, without calling it a nominated subcontractor, then things go rogue, go south and bad, and you'll go into arbitration, and you'll have to factually evidence that it was the employer who mentioned this, which again, extra time and cost.
So be careful with these things when negotiating aspects of construction contracts.
Thank you so much, Professor. Faisal, we are speaking about the clauses and the most common contracts issues. So can you tell us what is the most common contract clauses that lead to disputes from your point of view as a contractor representative?
From a contractor's perspective, certainly the vast majority of clauses in any contract can have the potential to lead into conflicts and, if not managed well, then, of course, disputes. However, I would say that there are certain clauses that tend to be more contentious than others in any given contract, and these tend to be the ones that we get to deal with on a day-to-day basis. Payment, for instance, is one of those. As our colleague, His Excellency Michael said, Lord Denning said that cash flow is the lifeblood of the construction industry. In fact, this was subsequently said by Sir Michael Latham to further emphasize on that in the report called Reconstructing the Team, Construction Reconstructing the Team. So certainly contractors, subcontractors, and suppliers alike rely heavily on steady cash flow. That is just the nature of how the industry works. However, when it comes to payment, it isn't just about the mere question as to whether a payment has been made timely or not, even though that is very important. However, payment clauses have got to do with so many other implications that may lead to conflict. For example, this could be to do with the valuation of the works for the purposes of certification. Unfortunately, in many instances, clients do tend to believe that contractors overvalue their works for the purposes of certification. So arguments in relation to valuation of the works do in many instances lead to conflicts. Other items in relation to payment are things like whether certain portions of the work be included under the preliminaries or whether they should be included under the permanent works, especially when the contract is vague and you've got preliminaries priced as lump sum and the other trades are priced as remeasurable, then you tend to get into these arguments whether the lump sum of the preliminaries should be all-inclusive of these items or not. Other clauses, again, for instance, to do with the valuation of variations. As you are aware, the vast majority of standard forms of contracts stipulate that variations are to be priced using the rates in the contract. Then if rates in the contracts are not applicable, then you would derive new rates through adjustment of the current rate in the contract. It is that bit that tends to cause problems, deriving the new rates, especially because certain elements of the work are not easily measurable. So for instance, if you've got a 2-meter wall and now it's 3 meter, that is easy. It's 2 minus 1, it's 3 minus 2, 1, that's the variation. However, when it comes to certain things that are intangible, such as design work is priced based on effort. The question of effort is very subjective. How much effort do you need to produce design? There is almost no answer to that. You just need to trust the design team. If they tell you it's 1,000 hours, then it's 1,000 hours. There is no way you can go and basically be on top of every single one of them to check whether they are working or not. These provisions tend to cause a lot of problems. Other than that, I would say clauses in relation to claims. When it comes to claims, I'd like to put particular emphasis on prolongation cost, on extensions of times and prolongation cost claims, because these are the ones that we tend to face almost on a day-to-day basis. So for example, the method of delay analysis is one issue that tends to cause a lot of problems. In reality, out of the vast majority of contracts I've come across in my life, I have probably only seen 1 or 2 that specify the method of delay analysis should the contractor claim an extension of time. I'd like to ask the gentleman, have you come across a contract that specifies the method of delay analysis?
Yes, I have, and it was totally inappropriate.
Okay, so
the contract actually provided for a prospective method of delay analysis for retrospective claims.
But we have to admit that very few contracts, including standard forms such as JCT, Joint Contract Tribunal, NEC, FIDIC, they seldom specify the method of delay analysis. So it's a very common argument that we tend to have almost with every contract administrator and client in relation to the suitability of the method of delay analysis used and whether it's fair for both parties or not. And then when we eventually conclude that argument about the extension of time, then unfortunately we tend to argue about the monetary aspect of the claim. When it comes to the monetary aspect of the claim, a very common question tends to arise, again, because contracts are silent. Should the contractor be compensated based on the rates stipulated in the preliminaries for time-related items, or should the contractor be compensated on the basis of actual cost? Given the background the gentlemen come from, I know that they will refer to the Society of Construction Law Protocol, which stipulates in its guidelines that it should be based on actual cost. But try to convince a client that a document that was issued in the UK by the Society of Construction Law says that, I'm telling you, there is no way you will succeed. That is a very common problem. Another one, if I may elaborate on that one, is again a very common question. Should the contractor be compensated for the period during which the delay took place in the project, or should the contractor be compensated for the period when the project got extended at the end of the project? Again, your immediate answer, according to SCL protocols, it should be during the period when the delay took place, and that is because resources were heavy. However, at the end of the project, you will tend to demobilize cranes and the vast majority of resources. But again, real life tells us otherwise, that a lot of the clients wouldn't want to entertain these arguments. So what I'm suggesting and what we are trying to do now, what I'm suggesting is a revision of these standard forms of contracts to suit circumstances of the kingdom. What we are trying to do now is to specify methods of delay analysis that to be used, to specify the way how prolongation cost claims should be calculated, and specify the duration in which the contractor should be compensated. Then it is no longer open to the interpretations of the parties. If I may elaborate also on another one, you've got those clauses that are to do with the contractor's design obligations and fitness for purpose, and that is with particular regard in design and build contracts. Whenever there is a change, there is always an argument. This is considered a change that entitles the contractor to additional payment and or time, or is it design development? Of course, most clients will say it's design development. As an experienced contractor, you should have known and you should have allowed for it, regardless to what the change is. From our side, in many instances, acting fairly as well, we tend to believe that this is a change. And that tends to happen more often in MEP trades, mechanical, electrical, and plumbing trades. For example, you have an introduction of a chiller room, and then the client would say, okay, but how would you have done it without the chiller room? Or you know what, I don't want the chiller room, but you need to cool the building. So they put you in those difficult scenarios. So that is a very common one. Again, I personally think that standard forms of contracts should be revised to allow for all these things and make them more explicit. Last, I would say, it is those clauses to do with what is considered unforeseeable versus what a reasonably experienced, competent contractor should have known. Again, this is an endless argument. Whenever something happens, the answer that you always get, you as an experienced contractor who've been doing this work for 7 years, you should have known. But if that is the case, then why do we have an unforeseeable clause? So when looking at the literature, I've actually come across a good reference point that I usually tend to use in arguments when it comes to claims, arbitration, and so on and so forth. Some have defined unforeseeable as the period that is 3 times the duration of the contract. Meaning, if you have a contract that is 5 years, if this event did not take place 15 years prior to the execution of the contract, then it's unforeseeable. We can argue about whether that's right or wrong, but at least we have put a definition against it. So, of course, there are other ones. as our colleague, Mr. Dr. Muhammad said, the inappropriate allocation in terms of risk. Again, many parties think that pushing a bargain too hard means that they win something. However, what tends to happen eventually is that the other party tends to get broken, and when you break the party in the middle of the project, what happens is they may just eventually walk away, and you end up with a problem. So these tend to be the common issues that we tend to face in relation to contract clauses.
Yeah, I'm more interested in the Q&A part, but I must say I'm absolutely grateful for your expose, I would say, presentation of important aspects of deep dive into construction issues. And I must say I fully agree with what you mentioned. The only last part I would, and I take it from you that you said at least we have a definition to start with. If we're going to take a temporal test as to define unforeseeability, I have issues with that. Because imagine 6 months down the road, subsoil conditions unexpected. This doesn't fit the test, but it's unforeseen. Events of geopolitical situation or supply chain tensions or disruption that are unforeseen are unforeseen. I recognize completely what you say about what would be a prudent contractor would have foreseen. But that is the element where a degree of reasonability and reasonableness and arbitrators or mediators or whatever would decide. And it's also important to factor into that an experienced contractor is not measured in the abstract. So if you are an experienced contractor in the US, it doesn't mean that you fit the test as an experienced contractor in KSA or in the Middle East. Let me tell you that. And all of you know that, but in reality, it has a lot of issues. Desert-like conditions are not similar to marine-like conditions, are not similar to humid-like conditions, are not
in
similar.
reality, if I may add to that, because we actually do tend to do a lot of marine work, even marine conditions in the eastern region of Saudi Arabia are very different from marine conditions
100%.
in the Red Sea because of the nature of the coral and so on and so forth.
Absolutely. And that is why the experience you talk about mainly relate to aspects that you would have taken into consideration. But the facts and event that defines unforeseeability are different. Now, you can tell me that we can define and contemplate certain events, they become foreseeable then. And they could be treated as part of the risk allocation matrix in that sense. But you're absolutely right, specifically about the design development and all these aspects. But that's part of the beauty of construction industry and disputes as they arise, and having a good dispute avoidance. And I must say, reasonable parties on both sides is important. Because if unreasonableness reigns, the reality is you're going to go to arbitration in that sense.
But if I may comment in this regard, when we say going to arbitration, even though I very much appreciate your experience, to someone like me, this is theoretical. Why? Because I have got a client that I'm planning to work with for the next 10 years. Yeah. So even though someone who's an arbitrator says, it's okay, go to arbitration. But that client I want to maintain a very good relationship with. And the moment I say to them, let's go to arbitration, and people in the market hear about it, then it means what? It means I'm no longer gonna be getting jobs with them. So that is blending theory with practice.
Exactly, but 2 points of that. I think the days where people are named and shamed as arbitrating are long gone, because in reality, it's part of the practice in the industry. Secondly, if you plan to do business with the client, you have 2 options. Concede or negotiate a deal.
Yes.
That's one way.
That's what we do actually.
Which is excellent. Or the other way, go to arbitration instead of 4 years regarding an interpretation of a contractual clause. How do we apply that clause? So it doesn't need to be that anyone is going to be...
what we do as well.
See? So that's a topic.
But there's another way. There's another way.
I mean, mediation is designed to preserve long-term relationships. And I think you said earlier in your presentation that within the kingdom you felt that there was a growth of ADR.
Absolutely.
And it's exactly for this sort of situation that ADR is designed.
Yes. So things like expert determination, mediation, negotiation, and so on and so forth, don't tend to have that, if I may call it, stigma, such as litigation and arbitration, unfortunately.
But DABs in particular, if they're used properly, if it's a standing DAB that's appointed at the start of the project and they know their role and everybody knows what they're supposed to be there for, which is to help parties resolve these problems without getting to arbitration at the end. DABs work brilliantly in other jurisdictions, appreciating the issue with the decision, but if both parties are keen to maintain that relationship, like you say, the standing DAB, and it is being used in this kingdom, I know of it, so it does work. I just think both sides need to buy into it and be realistic about it.
Last comment from
Just
Khushbu.
one last comment. I think the point is, Faisal, no one goes to arbitration immediately. In all our cases, the arbitration process is only triggered after 8, 9, 10 years. So there's some comfort that you have. You only use it when you know you're not getting paid. And I have many clients who really just use it to
as a last
get
resort.
pressure, even though they have ongoing relationship with the same developer or the same contractor.
Correct.
I think it's the time for going for Q&A. So if anyone has questions, and I would like please to ask it to be a questions, not a speech. So we need to be focused, give a question. And I will start with the first one, Dr. Nasser, then we'll give it to
thank you very much. My question in English. My name is Nasser Al-Adba, Oman and Partners, Riyadh office. My question to Professor Abdul Wahab and to Michael. Now we have seen trends and challenges. One of them is liquidation of the bonds, as Dr. Muhammad stated. And those bonds as advance payment bond, which is already paid by the contractor. So we have seen the counsels of the claimant, once they initiate the arbitration, those trends happens, the liquidation of the bonds. And then we have seen the counsels running to the court asking to stop those liquidations instead of going to the arbitrators, which they have already the powers of the interim measures. So we would like to see what's your insights to the counsels in this sense.
Well, that's actually a very interesting question because it's at the forefront of my experience at the moment. First of all, I have never seen a construction arbitration in this region where a bond hasn't been called, rightly or wrongly. But secondly, the issue of counsel going to the court and the powers of the arbitral tribunal is a very interesting one. Because, of course, the arbitral tribunal will have no jurisdiction to be able to restrain the bank from paying the bond. It would only be the appropriate court that would have jurisdiction to order the bank not to pay the bond. Having said that, of course, international jurisprudence very strongly says you do not, as a judge, order banks not to pay bonds. Bonds are meant to be like cash. And if you present the documents, if you satisfy the conditions of the bond, the bank has to honor that without reviewing the merits. But actually, it's quite interesting. I was just dealing with a case, slight war story, if you'll forgive me, but I was just dealing with a case in court recently where, strangely, the bond call went to arbitration. And the arbitral tribunal declared that the bond was valid. Then the bank itself ran off to a court and rather misled that court about the arbitral award and got the court, which was a bankruptcy court, to restrain the call on the bond. And then, in fact, the enforcement of the arbitral award came to me as the judge with the jurisdiction to enforce the arbitral award, which I did do, again, in reliance upon the reasoning in the award. The award, there was no reason to vacate the award in any way. It was binding. And also, in any event, it was right because the bank was bound to pay the bond. But it's interesting that we are now seeing a development, I think, where banks are resisting paying bonds. if they can. And this does lead to satellite litigation within the courts, because the arbitral tribunals will not, the arbitral tribunals who are dealing with the construction project will not have jurisdiction over the bonds. It's only quite rarely that I've seen that the actual bond itself has an arbitration clause in it. I don't know if there's anything you wanted to add to that.
No, absolutely. But let me take a step back. I fully agree with Michael, but let me take a step back. One has to consider a number of things, and that goes to Nasreen and Khushbu's point, and perhaps even Faisal's point about good counsel. One thing, if you are advising a client who wants to liquidate the bond, you need to look carefully and tell the client prudently that that is an extreme and a drastic measure that may affect the creditworthiness of the contractor, and so you have to consider it carefully and give a proper advice. Secondly, if you are on the other side and you want to be again prudent and an expert, you would have to look at when is the bond going to expire. Because if the bond is about to expire, then the only option is to call it. But if you are willing to extend the bond, the person who's calling the bond, or the party calling the bond, will look bad, because you have offered a solution to keep the bond ongoing up until. Now, Qatar specifically, and Dr. Nasser very helpfully set it out, is an interesting jurisdiction as well. Because I've had a case, and I think that is, sometimes you think you have seen everything until something comes your way which is surprising. I have seen a bond that has not been covered by the bank. So it's hundreds of millions. So the bond liquidation request has been submitted. A relief is requested from the tribunal to stop the calling of the bond, because as Michael has mentioned, normally the bonds include court clauses, not arbitration per se. And they are with the bank. They are a standalone document, they are a cash, separate relationship, completely understood. But in the contract, the construction contract between the parties, there is an agreement, a right and obligation. You would not call the bond unless X, Y, and Z. So this is where the jurisdiction of the tribunal is derived from. You have the ability, as part of an interim measure, between the parties, not addressed to an ex-party, that's the bank, to say, you as a party, for example, should withhold the calling of the bond until the tribunal has assessed the merits to see whether the breach has been triggered or not. And one way, the tribunal, you extend the bond or you put the money in escrow. Now, in that interesting case, despite the tribunal was convinced that the bond ought not to be called between the parties, and rendered a measure, interim, saying, put it in escrow or keep it with the bank, provided that it is extended. And that was issued as a procedural order. Procedural order. And this is the two things that I did not expect to see. The bank could not comply with the liquidation of the bond because the money is not there. The money is not there. 300 plus million. The bank covered the bond without cash. Yes.
But how can
absolutely.
A bond is an unconditional
Agreed.
obligation of the bank. If the bank has got a cash indemnity, tough for the bank.
Exactly. So the bank, it's exactly tough for the bank. It's because of apparently the creditworthiness or the reputation of that party. The bank said, I don't have the money. It's tough luck. Yes, you have to call it. I am not going to pay it. So the central bank sanctioned the bank. But the bank did not pay. And ultimately, you had a situation where back and forth discussions, but here is the interesting thing. The procedural order by the tribunal was set aside by the Qatari court. Set aside. You don't set aside a procedural order. You set aside an arbitral award. You may decide as a court not to honor the order rendered by the tribunal, and that's fine. But I have seen a set aside proceedings commence and the court setting aside a procedural order. So you live and learn. So the reality is, it happens. One has to be prudent and cautious, and contractors also have to be careful because you also have retention amounts as an employer. So you have the bonds, you have the retention amounts, you have the withheld amounts. So anyway, but it is an interesting problem.
I'd like to comment in this regard as well, if I may. One point that I think a lot of clients tend to miss is that calling a bond is not really a form of unjust enrichment, as in just to basically punish the other party and basically make a good amount of money in their bank. The purpose of the bond what they need to understand is that a bond has been provided to provide the client with mechanism to remedy and recover the costs as a result of the breach of the other party. So let's say, for instance, a bond's value is 100 million and the client encountered damages at 10 million. Then that doesn't really entitle them to recover the cost of the bond at 100 million, just because they've been provided with a bond. And that is something that we have seen recently in a court case in KSA.
Yeah, I looked at this recently in a court
matter, and I couldn't find any, as it were, local jurisprudence on it, but there is again international jurisprudence. There should be an accounting, and that if the liability against which the bond is called is only 10 million, but it's a 100 million bond, then there is an obligation to account for the other 90 million back to the contractor.
Yeah, that's what I'm saying.
Yes.
Okay,
Unfortunately, by then the damage is done, isn't it?
Abusive.
Yeah. The damage is already done.
An abuse of rights because it is disproportionate. But I know, anyway, not everyone likes abuse of rights in good faith.
Okay, can we go for the second question, please?
Thank you very much. Thank you for the insightful knowledge. Actually, I'm not a lawyer. I left the lawyering 15 years ago, and I was representing clients on more than 20 construction cases, and we did a lot of analysis on the construction disputes, and we distribute them into 50% engineer, 25% owner, and 25% the contractor. Why the engineer? Because the engineer, he is drafting the contract, he is putting everything in his favor because he is representing the owner, and everything is in his favor. So going back to your point on the design problems, because one, the owner needs to expedite the construction immediately. The engineer needs to add his fees because he needs to do a lot of amendments during the construction. So these are additional fees is adding to the construction. The engineer also, he is drafting the contract. He is just copying and paste from previous contracts, which are in his favor. He is the one who is managing these contracts. Going back to the engineer, appointing the engineer in the initial stage before the hearing, that's also the engineer will appoint, because the owner will go to the engineer, he's a personal representative to him, and he is going to appoint the engineer who is giving to a technical report on the case. So all these things related to each other. And I'm going back to Saad Faisal on having a good contract. I think it's not good. Otherwise, all of us will not be in this hole because there is no job for us. Thank you very much.
So the engineer is the source of all evil.
Thank you. Another question here. So can we give the mic to the gentleman here in the first row, please? Sorry, there's a gentleman before you. Can you give him the mic first, and we will come back to the question?
Thank you very much. Hello. Thank you very much for the insightful session. I have a question for Mr. Faisal. So you've mentioned that you are pro-specifying a delay analysis method in the contract, right?
Correct.
Okay, so I believe I'm strongly against actually this approach because you cannot simply foresee the most reasonable or the most appropriate delay analysis method that will be fit for a specific project because each project has its own records, its own circumstances, its own delay events, and not each delay analysis method is appropriate at a certain at each project condition and circumstances. So that's why again, because I've faced several challenges when it comes to specifying this analysis. I have to prove that it's inappropriate in this specific case or delay event. So this is the first question.
Okay.
Second, regarding the early engagement of lawyers.
Can we answer first the first observation
So
you are making?
specifying the method of delay analysis doesn't mean that you only specify a single one. Maybe you can nominate a couple of ones, or
Specify a code
or at least some sort of framework,
whether,
rather than just keeping it silent. That is what I'm trying.
You recommend a code or protocol.
Exactly, like SCL
ACE
protocol,
or
for
SCL
instance, or
or
something like that. Yes.
But can I interfere here? Sorry, Nasreen. The issue about the delay analysis is very critical. Okay, even when you mention it in a contract, I'm assuming with you are a contractor, okay, and the contract is silent. Everyone is playing for his favor during the contract. I'm not talking about dispute now. So the contractor will submit impacted as planned, while it's a very complicated project and it's required, for example, window analysis, a very complicated. How you will measure this? How you will judge on the methodology? Because the contract is silent about the methodology, and the contractor says the contract is silent about methodology. I can go and select whatever I like, and you cannot enforce me. So this put a burden on the engineer to make his own assessment, okay, on the contract and all the events, which may be creating an extra cost to the employer, for example. So how you will solve this situation?
True, but again, there is reliability constraints that impacted as planned. You cannot apply it in a project that has been already finished or in the peak in the execution phase. So again, it has to be a reliable method that is commonly accepted.
According to whom reliable? If we are not having a references,
you are not.
There are many research papers that you can rely on.
No, I'm not discussing the methodology. What I'm trying to discuss, by the way, impact as planned is a methodology in the SCL protocol, and we can use it.
It's not reliable and not acceptable.
You are not
by
working
most
for a
architects.
contractor.
It's reliable, by the way, in circumstances, for example, when you have an event after 1 week, after, for example, a change, pushing the. I don't want to go so technical. I'm sorry, but I'm just trying to go to the point back.
If I may ask, are you? I assume you're not working for a contractor. You are?
All my entire experience.
Because this is the way how contractors usually want to do it.
Impacted as planned?
Yes.
Of course not, because if it goes to arbitration or in any dispute meeting with any expert, it will be easily challenged, and then the contractor will be left in a very.
So how do you suggest resolving it?
Again, according to the circumstances.
Can
Yeah, but that is
bridge the gap, because I think you're talking at cross purposes. The reality is, both of you actually are right. Internally, contractors normally do internal for purposes of ongoing, impacted as planned. If you have a dispute, and I agree with you, if you have a dispute, it's not going to fly during the implementation. So you need credibility. So the change in methodology may result in a situation, and depending again on the type of implementation, if you are a project needing completion, 95% or 80% or whatever, impacted as planned will not work in reality. And so all the analysis you've done will fall down the drain. So you need to have a new one. But in reality, in-house, for whatever purposes, they continue to do it impacted as planned internally until you arrive at a situation when there is, and by the way, they even send claims to the engineers with impacted as planned.
It will be used against the contractors at a later stage, because definitely the engineer will plainly reject such analysis, and the contractor will stick to his position. No, I will apply the impact as planned. It will not.
But in the absence of express terms, there is nothing stopping the contractor from using impacted as planned. And that is what I'm saying. Therefore, in order to eliminate this argument, it is better to have something express.
Regarding the early engagement of lawyers, I just want to point out that from my experience, they should be engaged when the dispute is crystallized, and that means when a notice of dispute or a notice of arbitration is served. Engaging at the early stage, contrary to what some speakers here pointed out earlier, I also strongly disagree, because the contractor should handle this, the management or contract administration by his own competent, qualified team, and that doesn't mean that he doesn't have a qualified lawyer or contracts and claims professionals that should manage and handle, not calling for lawyers or law offices that engaged to understand the case and then charge contractors on an hourly basis and ending up with thousands of dollars, it doesn't work. So
but we're only
I want to
talking-
point out, sorry, some lawyers might disagree with such.
Your key word was qualified. You've got the qualified.
In-house,
Exactly.
as you mentioned, in-house.
That's the
competent
point,
in-house,
right? No, but that's the point. That there's a mismatch here because quite often the employers have in-house counsel who are construction lawyers and they are advising the project team. The mismatch is when the contractor doesn't have that. So as much as your colleagues on the ground might be qualified, are they qualified to the level of the in-house construction specialist lawyers that the employer has? That's why the consultants like me would come on board to help. So you need to think about if your company has in-house counsel who support in that way, you're in a very lucky position. But quite often there isn't that balance.
Correct.
And we are only talking about the relatively small proportion of cases where you are having problems on the project, which are insoluble by the normal give and take between contractor and employer. And what we're saying is, in that small proportion of cases, often one can promote the settlement of those disputes before they reach the stage for arbitration by an early engagement of experts and lawyers. That's all we're saying. So I think we're not talking at cross purposes.
I like this one. Experts and lawyers. It's nice. So we have a question here.
Yeah. How do you see the future role of mediation in the context of construction disputes? Should we move more towards a compulsory mediation at the outset? This is a generic question for the panel. I like the thought of Mr. Justice Black.
You'd like me to kick off on that? Okay. Well, I'll be controversial then, if I may. I actually do believe in some compulsion to mediation. I think sometimes people do not act in their own best interests. And I think sometimes they need to be brought to the table because experience has certainly shown me, and I'm sure that the rest of the panel will have their own experience too, that once you have brought them to the table and there is a competent mediator, parties can be shown as to where their interests lie and can realize that this process is actually good for them. Sometimes, you know, with a child, you have to force them to take the medicine. So sometimes you have to force the parties to take the medicine.
Well, maybe just two comments from my perspective from Singapore. I think since the Singapore Convention has been signed in the region, we've been pushing mediation a lot for technical disputes, and mediation is not but education again from my home jurisdiction in Singapore is the ARP-MED-ARP protocol, which some of you may know from the Singapore Arbitration Center rules. I think that works really nicely for really technical construction disputes because oftentimes, especially in the region, when government clients are your clients, they just do not want to sort of try and settle because of liability, because of face value, whole host of reasons. But with ARP-MED-ARP, the mediation comes in the arbitration process. Time it right, it's after the expert reports are already filed, and that's when they understand, well, you know, their case is not obviously rock solid and they have flaws, and it is in every case. And I think mediation is a lot.
Okay, thank you. My name is Husni Madi. I'm an arbitrator and a member of the ICC International Center for ADR Standing Committee and FIDIC Contracts Committee. So I take part of the guilt of drafting some of the contracts that you have just cited. This discussion has been really interesting for me as we benefit from the experience in the industry in drafting the contracts. But in 2019, we have published the Golden Principles, and I was one of the co-drafters of the Golden Principles. And at the very beginning, the most important thing is that the proper selection of the proper contract for the project. And this implies the proper understanding of FIDIC contracts. So, for example, with regards to the delay analysis methodology, little it is known in the industry that under subclause 8.5 in 2017, we raised a red flag for those who are drafting the particular conditions. And with that, you need to specify in the particular conditions the delay analysis methodology. Although I disagree with fixing a certain methodology, I would rather go with specifying a certain protocol or recommended practice. Because it depends on the circumstances. Yeah, it's not one size fits all. Secondly, and most importantly, it is known in the industry that there's something called two-phase procurement, where we have early contractors' involvement in the design process. My recommendation is please read the contract, read the FIDIC publications. For example, definition of unforeseeable is very clear. Experienced contractor is also explained. What does it mean? It's a legal fiction, and it's a fictitious personality. And you can download the FIDIC Golden Principles free of charge from FIDIC.org, shameless marketing, but I think it will benefit the industry. Thank you so much.
Hosni is always promoting for FIDIC, and thank you so much, Hosni. The next question for Shadi, Mr. Shadi, then we have the last question here.
So no females are asking questions?
Because they said at the beginning it's bad boys, so maybe you're afraid from this.
It's because the females know it all.
Right, thank you. And thank you very much. I want to take you back to perhaps 2 hours ago when Michael made his point regarding the efficiency of using experts in construction arbitrations. I want to very briefly share with you perhaps a different view than what you did, and I would love to hear your opinion on that, Michael. I think you related the inefficient use of experts to the parties and the councils not listening to the tribunals' procedures, trying to save them cost. My experience is slightly, perhaps quite different than that. In my experience, very rarely were the parties or the councils not following the tribunal's order or procedure order related to how the experts conduct their service. In my experience also, I have not at all perhaps find any tribunal intervene after the submission of the joint expert reports, where clearly the experts were disagreeing on the delay analysis methodologies, and they just let the tribunal let the flow goes on, and it's only in the hearing or perhaps after the hearing when the tribunal decide or find that the experts' report were not useful, and sometimes either appoint a tribunal expert or more surprisingly, perhaps conduct their own delay analysis in the award. So I think I would love to hear your view on these matters, and it would be very useful to also suggest how we can overcome it.
Thank you. First of all, I'm sorry if you thought I said that parties don't follow the procedural orders. That's not the point I was making. The point I was making was that at an early stage, one tries to discuss with the parties the shape of the arbitration. And my experience, and the experience that I know that others have had, is that when we try and float the idea with the parties of the early engagement of experts and the agreement of methodologies, even the agreement of the appointment of joint experts, all of these quite well-known procedures and well documented to be able to save time and expense in arbitration, we almost inevitably get pushback from the parties' counsel, who I assume are acting on the instruction of the parties. And I find it frustrating, my colleagues find it frustrating, because what we're trying to do is benefit the parties in saving time and costs, and yet they seem to be acting against their own self-interest because they believe somehow that it will compromise their cases. That's the first part of your question. The second part of your question is in relation to joint experts reports. It would be, for me, certainly as both judge and arbitrator, a standard order
that I would make. And for me, it is very much an agenda for the witness conferencing that inevitably I would undertake at the hearing. So I tend to order the joint expert reports pretty much at the end of the process in the hope that the experts have had time to reach some agreements. And then once we get to an oral hearing of the experts, then at least we know that the agenda is this is what they're agreed on, this is what they're not agreed on, and they can justify their disagreement to the tribunal, and the tribunal can investigate those grounds for disagreement. So that is the way I handle things. I don't know whether Mohammed handles them the same way.
Fully agree. The only thing perhaps for next year is to consider expert instructions. When the parties give experts different instructions and they tell you, I don't have an instruction to address this scope of work.
Can I also just make one comment on the role of arbitrators in this process? I mean, we all speak about experts and lawyers, but I think arbitrators have a role as well in this process. So many times, I think GS is quite common, but it's more about the timing of whether the GS comes sometimes before the individual reports or after. I think that's something we see, which is more commonplace these days. But many times, the arbitrator makes certain directions in the CMC or early on in the arbitration, and I think they leave the case to run as is for 2.5, 3, 4 years, and then it comes to the hearing and then realize, well, things were not going as they expected, and then make certain directions right at the end, as you rightly say in the hearing. So there needs to be early intervention from the arbitrator as well. He needs to read when we submit things, when we file it, not like years later or months later. I mean, he or she, obviously. When we file it, I think that direction needs to come quite early on. And a lot of the frustration we feel as lawyers is Justice Black is right. There's sometimes pushback for early engagement because parties are trying to settle the case at that point. So that's why they don't want to invest the cost in getting the expert. But we push back with our clients. We get the experts appointed. We do whatever is directed from the arbitrators, and then no one's really reading or looking at these documents, and that's another frustration. So again, it's the stakeholders coming together to make sure the process is effective from the arbitrators, from the lawyers, and from the experts.
Thank you for this interesting panel. My name is Ala Khater. I'm running a business in contract management in KSA and Quant Surveying in Egypt. You have discussed Ms. Nasreen, Mr. Faisal.
I'm so sorry. I can't.
Okay. My name is Ala Khater. I am providing services in contract management and quant surveying. I'd like to reflect on what you have said about risk management.
Do you have a question?
Yes.
It's a question, right?
Yes, sure. I'd like to reflect about what you have said about risk management and allocating the risk to the party who can efficiently manage this risk. But there is another aspect of risk management that is not appropriately considered by cost consultants, which is range estimating. Because providing an estimate as point estimate is putting some expectations for clients while getting into contract, and for contractors while they submitting their bids, they depend on a point estimate.
Does anyone understand the question or till now? It's a very technical. What is the question in easy language?
I'd like to say that you need to encourage range estimating while getting into bids and putting tenders, because clients, while they put their budgets, they depend on a single value. And this is not an appropriate practice, which leads to disputes because they do not have sufficient budgets, and so for contractors while they are preparing their bids.
So I will leave it to Faisal and Nasreen, since Faisal, he's the only one who understands.
I think I got the gist of the question, if I may answer. So, as we've mentioned in a few occasions today, that of course risk is best allocated to the party that is best suited to manage it. And of course, appropriate risk quantification is very important, and with every risk there should be a price to make sure that basically the whole spectrum of the cost is inclusive of all the risks in the project. So basically in this regard, I would say certain things like site conditions, site constraints, and so on, all of those should be taken into consideration. I think what you were trying to elaborate on is the role of the cost consultant. Is that correct?
Yes.
where sometimes cost consultants just take rates from previous tenders without examining the particular circumstances surrounding that particular job and without
No, sometimes
adjusting.
sometimes they consider that, but just they provide the estimate as a point estimate.
Yes,
And
so
this makes-
basically what I would say, it is very important for cost consultants to examine and scrutinize the rates. For example, if you've got a rate for earthworks where you've got contaminated ground, then it's very important to take that into consideration in your next job and not just assume it's the same because of the particular circumstances surrounding the rate. So I think in principle, that is what you are trying to say. We should not blindly take rates from one project to another, but rather give it more attention.
Thank you so much.
If I have answered the question.
Thank you so much. I think we need to close by the takeaways. So I would like to ask, like in one line or two lines, okay, each one of the speakers, if he would like to give an advice or a takeaway from this session, what he will do. I will ask Michael first.
Make better use of experts.
I will answer your question so that you don't tell us that we did not answer it about arbitration and construction. The latest statistics, for example, DIAC in Dubai, that is 50% of their cases construction related. ICC, SIAC and others were talking about somewhere between 25 to 30% construction related. Combined with energy, they make 40 to 45%. It is the industry which is there to continue. It's going to continue differently because of the impact of AI and otherwise. They even have projections up until 2037. We're talking about trillions of dollars and the top 10 destinations in relation to the construction. So in reality, arbitration continues to be used. Now, the process is going to change, the industries are going to change, presumably the players as well.
In one line, let's just allocate risk properly to those that can actually bear it.
So, if I can say that in one line, Vision 2030 is heavily reliant on construction projects. Construction projects are certainly adversarial by nature. It is inevitable that there is going to be a significant amount of disputes. Let's take advantage of alternative dispute resolution to be able to resolve our disputes quickly and timely and get on with the real work, which is delivering the projects.
I think for me, it will be better communication, both in the contracting stage, in the management stage, between the contracting companies, in the pre-dispute stage, and then finally in the dispute stage. I think that would solve so much problems. It wouldn't even go past through each hoop if you just have better communication.
Thank you so much. So I would like to thank you first for staying with us like 3 hours. This is the longest panel I think it's in the whole. I will take that. This is all business for me. This is the all expert promoting takeaway. No, actually, my takeaway, I would like to end with what Khushbu said. It's better communication, okay, better understanding, and hiring the qualified people. This is the 3 lines takeaway. But thank you first, and thank you to the panel, which was actually outstanding panel for today. Please join me thanking them. Thank you so much. I think we have some coffee outside, so we can have it, and let's take a picture together. The panel, please.